I've been doing a lot of consultations recently with permanent residents who are afraid of losing their status. And the consultations are usually about whether they should apply for citizenship or just renew their green card. And then we go through their entire history and make a decision on what's best for them in that particular situation. I thought I would make a short video about what could actually happen to a permanent resident if they are placed into removal proceedings. So the first question I get is, can I just be summarily deported? Like, can they just come, arrest me, put me on a plane and deport me? And the answer to that is no. They cannot legally do that. Now, whether or not that changes or the Trump administration starts doing more illegal things is yet to be seen. But generally speaking, 99.99% of people don't have to worry about anything like that happening. And courts have been striking down Trump's use of the Alien Enemies Act. So I'm hoping that practice comes to an end as well. But either way, permanent residents, to the best of my knowledge, have never been targeted under that Alien Enemies Act under the Trump administration. So permanent residents have an absolute right to a hearing. They have due process rights. You can't just be summarily deported. What can happen is you can be detained, especially if you're a danger to the community or a flight risk during your removal proceedings. So generally speaking, if you're living in the United States, the way you will be placed into removal proceedings is you will be issued a notice to appear in immigration court. And this could either be mailed to your home or hand delivered by an immigration officer. You can also theoretically be detained, especially if you've been convicted of any crimes or done anything dangerous, or the government's just targeting you because of something you did. If you are detained, you might be eligible for bond. And sometimes ICE will just release you on your own recognizance. Actually, I think that's what happens most of the time. They process you and then they release you because they don't have the capacity to detain every immigrant who's in removal proceedings. They usually prioritize people who've been convicted of certain crimes or are a priority in some other way. Let's say you are detained. What would actually happen? So if you're eligible for bond, which really depends on why you're being charged with removability from the United States, why you're being placed into deportation proceedings, your attorney would apply for a bond redetermination hearing. And then a judge would hold a hearing, and they'll generally consider two factors. One, are you a danger to the community? For this, they typically only consider your criminal history. They could also consider things like arrest reports or allegations, but mostly they're just considering convictions. It depends on the circumstances. The second thing they consider is whether or not you're a flight risk. So permanent residents usually aren't a flight risk, but if you're not a permanent resident, you can also apply for a bond redetermination hearing, and the judge will consider your ties to the community. Are you married? Do you have kids? Do you have a steady job? Do you have a place that you rent or own? These are all things the judge would consider to see if you're eligible for bond. And then what would happen is you would go to immigration court hearings, whether you're detained or released, and then your attorney would have to apply for a defense from removability if you are actually removable. There have been many times I've seen, and cases I've even handled myself, where immigrants are charged with removability, and at the first hearing, the Department of Homeland Security is unable to meet their burden of demonstrating that the immigrant is removable. And removal proceedings right there will be terminated by the immigration judge. This happened last year to one of my cases where someone was charged as being inadmissible for a certain crime in New Jersey. So that actually gets us into the second way that you could be placed into removal proceedings, and that is people who are inadmissible. So there are certain crimes that make you straight up deportable. The easiest example of this is if you've been convicted of a crime involving moral turpitude within 5 years of becoming a permanent resident. So you get your green card, and within 5 years, if you're convicted of certain types of crimes, you are deportable. Or at any time, if you're convicted of 2 crimes involving moral turpitude, you are deportable as a permanent resident. So that's why it's important to become a citizen as soon as possible, just in case you're convicted of crimes in the future, you could still get deported. However, you could also be inadmissible, but not deportable. So a crime involving moral turpitude makes you inadmissible. So let's say you become a permanent resident, and 6 years later, you're convicted of one crime involving moral turpitude. Remember, I said that outside of the first 5-year period, you need 2 crimes involving moral turpitude to be deportable. But if you're convicted of only one, 6 years after you become a permanent resident, you are not deportable, but you are inadmissible. So if you ever fly out of the US, when you come back, Customs is going to send you to secondary inspection, and then they're going to charge you as an arriving alien and charge you as being deportable and give you a notice to appear in immigration court. They might also detain you and transfer you to a detention facility. That kind of depends on the crime and a couple other variables. Interestingly, if you've been convicted of one crime involving moral turpitude outside of that 5-year period, the remedy oftentimes is to apply for naturalization once a sufficient amount of time has passed. That would cure the issue, and then once you naturalize, now you could travel internationally without being deportable when you re-enter the United States. Anyway, guys, that's just a quick primer on what removal proceedings might look like for someone who's being deported from the United States as a permanent resident. As a side note, you might also qualify for defenses from removability. For example, if you are properly removable for committing crimes involving moral turpitude, you might qualify for something called cancellation of removal for permanent residents. There might be other defenses available as well. So it's important to speak with an attorney if you've ever been convicted of crimes. And if you've ever been convicted of certain crimes, you should really speak to an attorney before you ever physically leave the United States, because those crimes might have rendered you inadmissible. One other quick side note, there are many other bases for being removable from the United States. It's not just criminal activity. And that is far beyond the scope of this video, because the Immigration and Nationality Act is a really long document, and you could just check out the section on removability if you want to see all the different ways you could be deemed to be removable from the United States. If you guys have any specific questions about your particular situation, you could always reach out directly to me. My consultation information is in the video description below. And if you're interested in more topics like these, be sure to let me know in the comments, and I'll be sure to create more videos like them in the future. I'll see you guys next time for another video.